Welcome to Texas Probate Made Simple under the KISS principle.
You're listening to Texas Probate Made Simple with G. Riley Hetherington, where we explain estate planning and probate for Texas families. Riley, of course, is a trusted attorney serving clients across Southeast Texas. I'm John Lieberman, and today Riley is walking us through one of the most important planning tools you can have, a will. This is episode 3, the benefits of having a will in Texas. Riley, it's nice to see you again.
Good to see you, John.
Let's jump in. What does a will actually do in the state of Texas?
A written will in Texas that meets the requirements of Texas law basically does 3 different things. It identifies and confirms that all of the assets of a person and the liabilities will be handled under the terms of the will for probate assets. And we talked about what probate and non-probate assets are earlier in episode 2. It also defines who the beneficiaries of that will be ultimately after all debts have been paid that are owed by the person who passed away at his or her death. And importantly, it identifies the individual that will be carrying on the duties of gathering up all the assets, paying all the debt, and then distributing those assets to the appropriate beneficiaries named under the will.
Riley, let me ask you this. I think the answer is everyone. But who should consider creating a will? And maybe even more importantly, when should they consider creating it or actually create it?
Well, it sounds like I'm upselling, but anyone 18 years or older needs to have a will. And actually in Texas, you can have it when you're 17 if you are married. But anyone above the age of 18 needs to have a will. Everybody that's below the age of majority, which is 18 or 17 if you're married, can't hold property in their own right. But anyone above can. And most people think, gee, we don't have anything yet. We don't need it yet, etc. But I can assure you, after reading some wonderful success stories of the billionaires that have made the money with all of the internet and AI, that by the time they're 19, they may be very wealthy. And certainly if you do it early when you turn age 18, then it's in place and it can take care of things if, God forbid, something happens to you. Because none of us, believe it or not, John, knows exactly when we might leave the planet. And so I'm a true believer, because of the issues we've discussed and will discuss, that having a will as soon as possible is very important. Finally, and we'll be talking about this more, I basically put a 10-to-1 basis on having a will as early as you can and not. And that is 10 times as expensive in time and money versus having a will exists by not having a will. So it costs you 10 times as much if you have to enter the inheritance, heirship mode of disposition and handling of properties after you pass away, as opposed to having a will. So candidly, it's a pretty inexpensive way to handle some very, very important issues and assets during your lifetime and after you pass away.
So to that point, Riley, how does a will actually simplify the probate process?
Well, again, a written will does several things. What it really does is reduces to writing all of the issues that we've been talking about in terms of gathering up the assets, paying the debts, making sure that the persons that are supposed to receive the assets receive them. And it's all set out in writing and can be referred to as far as the intent of the person during his or her lifetime as to how they wanted things handled upon their death. Additionally, we talked about in the first episode the difference between direct court control and non-direct
Mhm.
court control, or whether or not you have a independent administration, that is one that does not have direct court control, as opposed to a dependent administration, which has absolute probate court control. If you have a properly drafted will, then you can make sure that that independent administration of the estate takes place. And again, that's a lot of the 10-to-1 rule I'm talking about, because you have an enormous decrease in cost of time and effort to manage, report, and take care of things as far as the administration of the estate during the probate process.
And again, to your point, Riley, I'd imagine also a reduction in stress for the loved ones that you've left behind, because it kind of cuts down on the family disputes after death if you have a will, correct?
Well, again, I have to harken back to my KISS rule. And I have candidly spent a lot of time and a lot of my clients' money over the many years that I've been doing this in connection with family disputes, all of which can be substantially avoided, if not eliminated, if you have done proper estate planning with wills and what goes along with that. So let's go to the KISS principle again. K, you start with knowledge. You have knowledge of the person who has passed away's intent, which is set out in express terms under that written will document. I, instructions. Again, you have instructions by the person who's passed away that and that will bind the court, that can be followed as to how assets are to be managed, by whom, and who gets what when the distributions are made. S, selection. You've got selection by the person who's signed the will in expressly stating as to how the assets will be handled, and again, how they'll be distributed. And finally, the final S is settlement. You have settlement of any possible claims by any of the beneficiaries or family members in relation to those assets. And that settlement has occurred by the stated intentions and written instructions that are contained in that one document. So you really have a situation where family disputes are many times completely removed, and family disputes don't exist because everyone knows what the rules of the road are, and those rules of the road have been set by the person who passed away, signed the document, and made those decisions for everyone before they left the planet.
So it sounds like it's going to be everything in the inverse, but what happens if someone in Texas dies without a will?
Well, I mentioned it in episode 1. So now you're entering the arena of an heirship proceeding, where the law has to determine who the individuals are that are to receive the assets of the person who passed away. That's all taken care of under some provisions of the Texas Estates Code. What also happens when you don't have a will is that the Texas Estates Code also sets the rules as to who is appointed to be the individual who administers those assets and takes care of all the issues of gathering them, paying bills, and then distributing. And finally, after you've had to determine who's entitled to the assets, the Texas Estates Code sets out percentages of who gets what under those circumstances, which candidly can be very different than what the person who passed away ever could envision at the time that he or she didn't prepare a document. So again, that heirship proceeding is a 10-to-1 situation as far as time, cost, and expense, and can all be avoided if you have the will. But that's what happens when you have an heirship proceeding. We'll talk about that later in the next episode, but I can assure you that those references to the Texas Estates Code surprise people, and quite often, and for the most part, will never satisfy all the things that a person could have taken care of during his or her lifetime if they would have signed a will.
So I know we're going to dig deeper into it, but let me ask you a couple quick questions. Are there special considerations for blended families?
Well, you're speaking to someone who has not just been married once, been married 3 times to wonderful people. And my first marriage ended with all the children that my 3 daughters, but I can assure you that's not the rule. People get married a lot to different people. People have children a lot by different people. And there are lots of stepchildren. And in most of the cases that I see, stepchildren are involved and prior marriages, et cetera, are involved. Well, what happens is that the Texas Estates Code deals with that situation very differently as to who gets what. A quick side note. In Texas, we have what is called community property and separate property. It's a way of characterizing an asset depending upon when you acquired the asset. And it all relates to marriage. If you get married in Texas, it is presumed that any asset that you buy, acquire, or get after you get married is called community property, and it is owned 50-50 by each spouse. On the other hand, a person can have what is characterized as separate property, and separate property is defined as anything that you bring into the marriage you have before you get married, or that you acquire during your marriage by either someone giving it to you, someone leaving it to you under a will, or by someone leaving it to you under the inheritance laws. Why is it important? Well, when you have the community separate designation of property, that's when stepchildren issues really come into play. And quite often, stepchildren end up with interests in real estate and percentages in assets owned because it's characterized as either separate or community property upon a person's death. And again, I can assure you that's typically when the fights start, and that is typically when the 10-to-1 expense rule really comes into play.
I'm sure of it. Riley, can a will be used to name guardians for kids or pets even?
You definitely can name guardians of persons and estates in your will. You can do it by separate instrument. You can definitely do it under your will. You can name guardians for your children, both their estates, what they own, and then who takes care of them in your will. And that's a very, very common and very good thing to do. And trusts can now be created and have been for the last 20 years for pets in Texas. And those are really, really well done. And you can set aside money to take care of a pet after you have left the planet. And who would administer those funds for that particular pet? Really, really interesting, neat stuff that can be done in the estate planning process in Texas to take care of both. And if you're like most of us, possibly the closest relative you have is either your dog or cat. So it's a really, 100%. Really, really neat thing to be able to do it again as part of the estate planning process.
For sure. Hey, Riley, what are the requirements for a valid will in Texas?
We have 2 kinds of wills in Texas in writing, and that's the first requirement. We have what is called a holographic will and a non-holographic will. A holographic will is a will that is wholly in the handwriting. Everything's in the handwriting of the person who passed away, who signs and dates that particular written document. A non-holographic will is not wholly in the handwriting of the person who passes away. It's the typical thing you see is prepared by lawyers or some of the internet documents that are prepared that are typed, etc. A non-holographic will in Texas has to be witnessed by 2 people who are not related to the person who typically are not related to the person who passes away. and who witness the signature in the presence of that person who signs the will. So those are the only two types of will that ultimately can be confirmed with a written order of a probate court to be the last will and testament in Texas.
So we all hope to live a long time, whether you're in Texas or not. So I want to get your opinion, Riley. How often should a will be reviewed, updated, and the like?
We try to put our firm on a 3-year review basis to at least send out a note to everybody saying, has anything important changed in your life? And that's the determining factor of how often it ought to be reviewed. If you have a divorce, if you have a birth, if someone that is named in the will passes away, all of those life events should trigger in your mind a notation to, hey, maybe we ought to pull our old will out and take a look at it and make sure that it's timely. So those are the types of events that should immediately trigger it. And like I said, I think for a person, and should follow at least what we try to do at the firm, and send and look at it at least every 3 years.
Good advice. Good advice. All right. Thank you so much for your time, Riley. And thank you for tuning in to today's episode of Texas Probate Made Simple with G. Riley Hetherington. If you haven't made a will yet, or you haven't looked at yours in years, visit hetheringtonlaw.com to get started. Riley can help you create a plan that fits your family, fits your values, takes care of your kids, takes care of your pets, everybody in the family. And please be sure to like, review, and subscribe for more helpful episodes just like this one. Thank you so much.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.